Good evening. Hello, hello, hello. Will be shown. Okay. Hello. I'm getting myself sorted out here, but welcome in. Welcome in. Hello. Good evening. Good evening. Hello, everybody. Thanks for coming over. I got to get myself sorted a little bit. A little different format over here, but that's good. We love it. Hello, hello, you made it. Good job, Grandma. Is it GMA for Grandma? Grandma the Pulse. I love that. That's fantastic. Hello, hi, hi, hi. Oh, Frank, good to see you. Here we are back again, right? We keep going back and forth. We'll figure it out eventually, right? Hopefully, fingers crossed. YouTube's so much better than TikTok. I agree. I agree. And, I've talked about this for a while, everybody, that, YouTube chat is actually pretty user friendly for creators too. So I think we're going to be just fine over here, everyone. Is this your summer house? It is. This is where we summer. Oh, Grandma. Okay, okay, good. I don't know. There can be lots of people with GMA as their as their letters. Just want to double check. Hello, Nita. Yes, yes. Welcome, welcome in. Welcome in. Break out the lemons. Oh, I know. Hello, Kathy. Oh my gosh, it's good to see you. Good to see all of you. I'm so glad you came over here to hang out. I think, and a lot of creators feel this way too, but we're really kind of having to rebuild. I didn't spend as much time on YouTube as I probably should have, but there's only 24 hours in the day, right? Yes, I am a bit early, to see if people get notifications and also to give them a little time to come over before we get started tonight. On the 80s TV, sweet! We love it. We love it. Hello, Lee. Welcome. Welcome. I'm glad you made it. So, yeah, oh my gosh, how stressful was it today? I set my alarms so that I could get up and be like, all right, what's the Supreme Court gonna hurt today? Who's the victim today? And they just didn't give us an answer on our case. So, does YouTube give notifications? Yes, yes, they do. You have to hit that bell. There's a little bell for notifications, and then that'll tell you when any of my posts come out and when I'm live streaming. Okay, yes, yes. Oh, you got your notification. Okay, love it, love it. Couldn't stand the hearings. Oh my gosh. I tried to listen in. I'm like, well, this is important. I should know about it. And then I would tune in for 2 minutes and I'm like, no, this isn't going to work. Not for me. It's not for me. I'll just hear the highlights later on in comedic form. Oh, you got your notification? Oh, great, great, great. Oh, I love it. I love it. So our format is a little bit different over here, everyone. Yes, subscribing is free. Thank you for reminding me of that. So if you want to subscribe, it's free. And then that way, if you hit the bell, then it'll give you notifications when I go live. And then when I'm also posting. Now, the majority of my posting over here, I've got to kind of do things a little bit different with short form versus long form. Mostly I have my posts are 3 minutes or less over on TikTok, but there are a few that are longer. So for the longer ones, I'll be posting maybe, every other day, the longer videos. But I am trying to post multiple shorts each day to kind of get my content over. But I will be starting fresh new content next week. So that's very interesting. They asked that the lady who won the 2020, she didn't answer. Oh, that's not a good sign. That's not a good sign. Like, no, ma'am, I'm going to need you to answer that question. I'm going to need you to get that sorted out. So do you edit videos on YouTube? Now, I could, but for me, it's actually easier for me to edit them through my camera, right? Because I don't have, like, I'm not putting makeup on, so I'm not needing those close shots. So for me, I don't have a lot of bells and whistles. I just have paperwork. So it works out okay for me too. For me to just use it on my camera, get it sorted out. Yeah, it's infuriating. I know. It's awful. It's awful. Yeah, so I'll edit most of them on my phone. I'll probably dabble in the YouTube to see how it works, but I don't want to watch anyone. They aren't answering the questions. Yeah, exactly. And that's really frustrating. It's really frustrating. Do you have Hulk moments here too? Yes. So I'm glad you asked. The one thing that I will caution everybody is that I'm going to have to merge my two TikToks, my two TikTok channels into my one YouTube. So the Hulk's going to be coming out. She's going to be coming to visit. So that'll be, yes. Oh my gosh, that's so frustrating, everybody. It's so frustrating when they don't answer. So anyway, I know. Yeah, watch out, everybody, because she'll be here. Not quite yet, but I think this weekend she may visit because this stuff's crazy. We're in a crazy talk time. Oh my gosh. So let me just make sure we've got everything here set up. So I do have moderators on that are here on my schedule, but I'm wondering, I was wanting to look real quick to see if I could add more, because you can add more if you are, here we go, here we go. All right, I got it. I got it. Did I find it? Did I? Yes, I found it, everybody. Whew, sorry about that. I can't finish my thought right now. I'm still just like, what? In my own world. So, right. So if anyone wants to join as a moderator as things get going, I can do that later on. I just have a few right now because I think that's really all we need over here, but I can certainly add some later on. I hope you have plenty of lollipops. You know, I had to switch. Look, everybody, this is so sad. This is as sad for me as TikTok going away because I need to say things like that to comfort myself. So I have I have Werther's Original instead of my lollipops, and it's sugar free because my teeth person was like, "Don't be sucking on those suckers." So I had to switch to sugar free suckers, everybody, and I'm not sure about that. It makes me feel a little sad that we've gone we've gone over there. Oh my gosh. Yes. Yeah, we're yeah, I know. Oh my gosh. I had someone say, well, isn't that what like grandma and grandpa always had? The butterscotch? I'm like, you be quiet. Don't judge me. I can't help it. Oh my gosh. All right. So, for anyone who's new here, everyone, you should note in the chat that it works just a little bit differently when responding to other people and your names too. So, if you want to change your name, you can absolutely do that to either match what you were over in TikTok. So, when people are chatting with you, they've got some idea and can remember who was there. Because I think in TikTok that was one of the great things was that you could kind of comment to other people. So we can keep our community going forward here that we have made together, just with a little tweak here and there, but should be pretty good. Hello, Navy Vet. Yeah, you're here. Woohoo. Terry, yes, hello. So, Buzzing Bee, hello, welcome. I'm so glad to see you. So, we can all still hang out and have a lot of fun. It's just a little bit different format and less censorship. So, I'm okay with that. Oh my gosh. Yes, it's up to you if you wish to change your name or not. You don't have to, but I know a lot of people do so that, the people in the chat, you guys can recognize each other. Some people just say this was my other name and then keep their new name. So it's up to you. Whatever flips your boat is absolutely fine. So with that, now I wanted to come in and do the next piece. I've been reading through the report that was delivered from Jack Smith to the Attorney General. All right. So he hand delivered this report. It's 174 pages, and this is the first volume. Jack has a second volume, but Judge Cannon has refused to allow that to be released. So she's requested briefings as well as a hearing to discuss whether or not to release it. So I think that's going to take a few months to get sorted out. So we're really only able to kind of look through the DC report because that's really the only one that's available to us. Actually, I can pull this down now that the chat is moved. to a different place. Can everybody still see everything? I'm not sure. If you're watching it on your phone, you may have a little bit of the chat over it, but it should be okay. Bye, saying goodbye. Yeah. Any name other than anything containing the word orange. Yeah, we do have some language. Oh my gosh. Yeah, yeah. I know. Garland was yikes. That could have gone better with Garland, I think, but you know, it is what it is. So we step back, regroup, and live to fight another day, right? Yikes. That's kind of my I keep telling myself that. So yeah, exactly, exactly. All right, everyone. So here is so don't forget. So here is the report again that was given by Jack Smith to the AG, and this is all of the DC stuff. We're waiting on Florida. So I have read through some pages. So let me just kind of explain where I've read to. So the first few pages are Jack's letter to the AG, where he sets out, you know, I had a really great team that I was able to work with, and I'm really thankful for that. We followed the rules, we followed the law. I was appointed to do this. This is what I did, and then we move forward. So I thought that was a really nice letter. And then I started diving into the table of contents here because he broke each piece apart. And I thought one of the most interesting things, too, is that he has the principles of federal prosecution. And that just means that these are the rules of the game. So in order to go forward in a federal prosecution, you have to follow the rules. And so he sets the rules out and then explains how he followed them. So that was very helpful because we had a couple of pieces in here where people were saying, well, why didn't he charge treason or insurrection? And he goes into that and explains why. So, you know, I thought that was very, very helpful. And then after that, we went through, okay, it's not too bad on the phone. Okay, good. Just keep me posted. But he went through kind of this introduction piece. So I've read through volume 1, the results of the investigation. 2, now the first, I have 3 videos to have come up on YouTube, 3 live streams. Today I posted the pre one where we talked about the motions and things that both sides filed before this report came out. And then the next one that I will be posting will be that introduction piece with that letter and kind of just looking through it. And then the third one will be last night, where I made a little bit more, a little bit further through the report. So tonight's technically part 4, and I will have the other parts up and running on YouTube here pretty soon. So again, it takes, oh my gosh, it takes a really long time for some reason to pull the live streams off of the talk and put them onto the YouTube. So it takes a little bit of time to do that. Name on your account would be under, yes. Oh, hello, VC. Hello, welcome. Desert Skies. Welcome. Good to see you. Oh, Barkside Banter. Yes, I don't know. Do you want to change your name? That's kind of a fun name. I'm just kidding you. So for anyone who's new, you can feel free to change your name so that it kind of, shows the rest of us who you were in the chat over on the TikTok. But you don't have to. So it's up to you here. We've got several moderators here also to come and hang out. And so that should be set. I have noticed a lot of trolls kind of coming through YouTube recently, so hopefully they'll stay away from the live. But, you know, we can just only have so many wins in one day, right? Can we have a win today? I would really appreciate a win today. That would be great for us. Oh my goodness. All right. So with that, the last thing that we discussed yesterday were these pictures of this peaceful protest that they're claiming it was. And then that took us into another big piece of his explanation of the evidence. So that's what we will start there. Okay. Oh, Boxer Mom. Yeah. Okay. Very nice. Got it. So let's dive in, everybody, and we'll start going through this one, and then we can kind of discuss the goods and the bads with it. So Because I'm thinking about lollipops, I'm going to use my lollipop pen. As I had explained to those that were here first, I had to switch to sugar-free, and I'm really disappointed. I think it's just like, oh my gosh. All right. Yeah, we've got, I know. All right, so let's go ahead and dive in, everyone. We'll pick up where we left off, which was, again, looking at these photographs of the DC situation. So these were put in, again, to show the guardrails going down and the police being harmed as well. So those pictures came in. And Jack was going into the beginnings of Mr. Trump's speech that day. All right, so let's dive in. Here we go, we're on page 29. So I've noticed that I've got the name of this document on my screen, but does everyone else have it, or should I put up a sticky note? Because I can put a sticky note in here. I'm just not sure if the title's transferring over on the phones. Bottom right corner. Oh, there you go. Okay, there you go. Okay, excellent, excellent. So yeah, I can do a sticky note if everyone would prefer that, or if we've got enough information showing up on the screen, we can just go that way. So we'll see. Do we have any preference? Or are we all just tired of making decisions today? I'm a bit burned out on making choices. So, all right, well, well, we'll see. We'll see how it goes. And if we need a sticky note, we can always add it. So, all right, let's dive in. Page 29 here. This is okay. Okay. Decision fatigue. Oh, I know. Man, I can't even decide if I want smooth or crunchy peanut butter these days. I just can't. All right. After his speech, Mr. Trump returned to the White House and at around 1:30 p.m. settled in the dining room off the Oval Office. There he watched television news coverage of the events at the Capitol and reviewed Twitter on his phone. When the angry crowd advanced on the Capitol building and breached it at around 2:13 p.m., forcing the Senate to recess, several of Mr. Trump's advisors rushed to the dining room and told him that a riot had started at the Capitol and the rioters were in the building. Over the course of the afternoon, they forcefully urged Mr. Trump to issue calming messages to his supporters. Mr. Trump resisted repeatedly, remarking that the people at the Capitol were angry because the election had been stolen. Just before 2:24 p.m., the news channel playing on the television in the dining room where Mr. Trump was sitting aired an interview with an individual marching from the ellipse to the Capitol who expressed his anger at Mr. Pence and stated, "But I still believe President Trump has something else left." Then at 2:24 p.m., sitting alone, Mr. Trump issued a tweet attacking Mr. Pence and fueling the riot. Quote, "Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent and inaccurate ones which they were asked to previously certify. USA demands the truth." End quote. 1 minute later, the United States Secret Service was forced to evacuate Mr. Pence to a secure location at the Capitol. When an advisor at the White House learned this, he rushed to the dining room and informed Mr. Trump, who replied, quote, "So what?" The rioters at the Capitol had been motivated and directed by Mr. Trump, and he continued to resist advisors' requests directing them to leave. Throughout the afternoon, crowds at the Capitol hunted for Mr. Pence and other lawmakers, with some chanting, quote, "Hang Mike Pence," end quote. At 2:38 p.m. and 3:30 p.m., Mr. Trump issued two tweets, falsely suggesting that the events at the Capitol were peaceful and asking individuals there, whom he termed "we," to remain that way. "Please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful." And, quote, "I am asking for everyone at the U.S. Capitol to remain peaceful, no violence. Remember, we are the party of law and order. Respect the law." Oh my gosh, that'd be great if you could respect the law. That'd be a banner day for us. After his speech, Mr. Trump, hold on a second. I already read this one. Where'd we go? Oh, I got thrown off. I was on 30. I have to flip my 32 over. Sorry about that, everybody. There we go. I'm getting myself sorted out. It's been a day, everyone. So let's come back over here. And he's saying, respect the law and our great men and women in blue. Thank you. At 4:17 p.m., he tweeted a video message in which he, for the first time, asked his supporters to leave the Capitol, while at the same time falsely claiming that, quote, we had an election that was stolen from us, a landslide election, end quote, and embracing the people who attacked the Capitol, telling them, quote, we love you, you're very special, end quote. And at 6:01 p.m., he tweeted, quote, these are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long. Go home with love and peace. Remember this day forever, end quote. At around the same time as he issued the 6:01 p.m. tweet, Mr. Trump tried to reach two United States senators, and he also directed co-conspirator one to call members of Congress and attempt to enlist them to further delay the certification. When Mr. Trump's White House counsel called him at 7 p.m. and asked him to withdraw any objections to the certification, Mr. Trump refused. Nonetheless, the certification resumed late in the evening of January 6th. And let me make sure I'm on the right page. Yep, I am. Let's make sure. Page numbers matter. January 6th, and at 3:41 a.m. on January 7th, Mr. Pence announced the certified results of the 2020 presidential election in favor of Mr. Biden. As he did in his 4:17 p.m. and 6:01 p.m. tweets on January 6th, Mr. Trump has provided additional evidence of his intent by continuing to support and ally himself with the people who attacked the Capitol. He has called them patriots and hostages, reminisced about January 6th as a beautiful day, and championed the January 6th Choir, a group of January 6th defendants who, because of their dangerousness, are detained at the District of Columbia jail. All right, so next section is to go through the law. And I'll kind of, we'll take a peek at this just a little bit because I have kind of gone into this before. So we'll kind of skim through here, everyone. Taking my tea break. Yes, we haven't, John. Oh my gosh, you noticed. John, don't tell everybody. Oh my gosh, but yes, so I have a stubborn one that will not go away. And so I'm dealing with it. Hold on here, John. I'm adding you on as a moderator. So okay, excellent. There you go. All right, so here we go. Yeah, this one's not coming off. I had to put a different one on. I know. The world's gone crazy when I can't get my nails to work properly. Yikes. All right, here's the law. Based on the above facts and after analyzing the relevant criminal statutes, the office sought and a grand jury found probable cause for an indictment of Mr. Trump on 4 federal charges: conspiring to obstruct the governmental function of selecting and certifying the President of the United States in violation of 18 U.S. Code Section 371, obstructing and attempting to obstruct the official proceeding on January 6th of 2021 in violation of 18 U.S. Code Section 1512C2, and conspiring to obstruct the official proceeding in violation of 18 U.S. Code Section 1512K, and conspiring to violate federal rights of citizens to vote and have their votes counted in violation of 18 U.S. Code Section 241. So, of course, that's your civil rights violation because of voting. Next, because of the unprecedented facts and the variety of legal issues that would be litigated in this case, the office was aware that the case would involve litigation risks, as would any case of this scope and complexity. However, after an exhaustive and detailed review of the law, The office concluded that the charges were well supported and would survive any legal challenges absent a change in the law as it existed at the time of the indictment. So he's just coming in and saying we had everything that we needed to go forward on a conviction. And although the Supreme Court kind of dinked around a little bit with 1512, C2, and K, even with that, they felt that they had a strong case to go forward on. Can't see. Am I too far away? Do I need to get a little bit closer with my camera, everybody? Are we struggling? Haven't able to get that. Oh, I know. Yeah. All right. Well, let me know if you need a closer view. I think you can also, you can see it okay? All right. It's just blurry. Okay. Well, that I can't help you with because everything looks blurry to me. There we go. I'll get a little bit closer. We'll see if that helps a little bit. There we go. It's fine. Okay. We'll see if this helps a little bit. We got a little bit closer. It should narrow in a bit easier. All right. So here we go. Time of the indictment. Okay. It's fine. Great. Thank you. All right, next up, as set forth in section VD below, after the original indictment was returned, the Supreme Court ruled in Trump v. U.S. that Mr. Trump had absolute immunity for core presidential conduct, enjoyed a rebuttable presumption of immunity for other official presidential acts, and had no immunity for unofficial conduct. The Supreme Court's decision required the office to reanalyze the evidence it had collected. The original indictment alleged Mr. Trump, as the incumbent president, used all available tools and powers, both private and official, to overturn the legitimate results of the election despite notice, including from official advisors, and his fraud claims were false, and he had lost the election. Given the Supreme Court's ruling, the office reevaluated the evidence and assessed whether Mr. Trump's non-immune conduct, either his private conduct as a candidate or official conduct for which the office could rebut the presumption of immunity, violated federal law. The office concluded that it did. After doing so, the office sought and a new grand jury issued a superseding indictment with identical charges, but based only on conduct that was not immune because it was either unofficial or any presumptive immunity could be rebutted. This section reviews the federal laws violated by Mr. Trump's non-immunized conduct. So he's setting it out here again to say, look, we just cut out all the pieces that you didn't like and had another whole nother grand jury come in and explain it. All right, so let's go through. And this is how he's going to split between the immunity pieces and the actions that were not immune. So I think this is really important because, again, I've been talking about this. We have a civil case in DC, the Blessing Game case. It's actually a set of cases where they're suing Mr. Trump for his actions on January 6th, saying he set this up and they were harmed. So we have police, we have various other people that were at the Capitol suing for harm done to them, for assault and various other things. So that lawsuit is still going forward. And right now they're trying to set the schedule to argue immunity. So even though it's a civil case, so I think this will be helpful for Blessing Games cases, as well as for the rest of us to see how the Justice Department super guy looks at that term, because we've got some questions about it, right? We don't have any definitive answers on what exactly is immune and what is not. So I think this will give us a really good head start in that direction. So A, conspiracy to defraud the United States. So this is section 371. The defraud clause of the general conspiracy statute makes it a crime, quote, if two or more persons conspire to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, end quote. So that's section 371. The defraud clause applies not just to schemes to cheat the government out of money or property, but also to schemes to interfere with or obstruct one of its lawful government functions, by deceit, craft, or trickery, or at least by means that are dishonest. And then we are citing the Hammerschmidt case out of 1924. And so that's the first piece. Under long-standing established precedent, the government must prove the following elements to establish a violation of the defraud clause. Number one, the defendant entered into an agreement. Number two, to obstruct a lawful function of the government or an agency of the government. Number three, by deceitful or dishonest means. And number four, at least one overt act was taken in furtherance of that conspiracy. So I would say every single state, everybody's state has their own definition of conspiracy. This is the federal definition, right? So when he's saying at least one overt act, for example, in the Georgia RICO case, they need two overt acts, but you just have to show that they have been moving towards doing the harm, not that they completed the harm. So that's really important to remember when we charge people with conspiracy. A lot of people kind of are like, well, it didn't really happen, so it shouldn't be charged. But again, conspiracy is one of those where it's the idea and the step towards the illegal act that gets you charged. The process of selecting and certifying the president, as described above and prescribed by the Constitution and federal laws, is plainly a lawful function of the federal government. And then we're citing the Blair case, 1952, noting that the presidential electors exercise a federal function. And then continuing to cite case law, stating that electors exercise federal function under and discharge duties in virtue of authority conferred by the Constitution of the United States. And then Brock is stating, noting the unique congressional function of certifying electoral college votes. And then that's end quote for his last case that he's using. So just showing what law there is to show that electors are part of the federal application of the criminal law. Indeed, Mr. Trump never challenged the indictment on that basis, though he filed more than 100 pages in support of dismissal motions. Yeah, it feels like it was much more than 100, everybody. As the Court of Appeals found in the context of the immunity litigation in this case, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. And citing further case law, Mr. Trump also sought to obstruct the certification. His sole objective was to ensure that no one other than himself was certified as the president. Nor is there any doubt that Mr. Trump conspired with others to achieve his goal, and that at least one overt act was committed. So again, Jack's going through and saying we had everything we needed to go forward with the charges that were done by the grand jury. With 3 of the 4 elements of Section 371 violation established, the office anticipated that a central dispute at trial would be whether Mr. Trump pursued his obstructive purpose by deceit, craft, or trickery, or at least by means that are dishonest. So he's saying that this is what they really thought was going to be the issue here in this case, was whether or not his intent lined up with what was required in the statute. The office concluded that the evidence established beyond a reasonable doubt that he did. And again, beyond a reasonable doubt is what you need to convict in a criminal case. Probable cause is all that you need for a grand jury to go forward with an indictment. So it's a higher level of proof, it's a higher burden. And what he's saying here is that we had the evidence to meet the burden of proof that's required in front of a jury. So that's what this whole piece here is about. We had it, we could have done it. The core of Mr. Trump's obstructive scheme was a false narrative of outcome determinative voter fraud, which he and his surrogates frequently repeated and widely disseminated over the course of 2 months. Crucially, not only was Mr. Trump's voter fraud narrative objectively false, he knew it was false. Mr. Trump's false claims were repeatedly debunked, often directly to him by the very people best positioned to ascertain the truth. Campaign personnel told Mr. Trump his claims were unfounded. So did state officials. A White House official who engaged with Mr. Trump in his capacity as a candidate and even his own running mate. For example, Mr. Trump's campaign manager informed him that a claim had been circulating that a substantial number of non citizens had voted in Arizona was false. State officials issued public statements dispelling Mr. Trump's claim of widespread fraud. Georgia's Secretary of State refuted multiple false claims of election fraud directly to Mr. Trump, including the false allegation that 5,000 unalive people had voted in Georgia. When Mr. Trump raised various fraud allegations with Michigan's Senate Majority Leader, he was told that he had lost because he had underperformed with educated females. Vice President Pence told Mr. Trump that he had seen no evidence of outcome determinative fraud in the election. And tellingly, a senior advisor reiterated to Mr. Trump that co conspirator one would be unable to prove his false fraud allegations in court. To which Mr. Trump responded, quote, "The details don't matter." Yikes. Tea break. The details do matter, everybody. Okay, that's where the devil is, right? In the details. Right, sorry. Maybe that was a dad joke. Too soon for dad jokes. Courts in which Mr. Trump brought numerous lawsuits all rebuffed his claims, which in some instances prompted him to issue public rebukes acknowledging those decisions. Still, other federal and state officials, some appointed by Mr. Trump, and others who publicly supported and voted for him, publicly debunked allegations of outcome determinative of voter fraud. Mr. Trump did not reach out to any of these officials to ask relevant questions about the election because he was not seeking honest answers. Now, I think this phrase is just, I'm going to highlight that because I think this is a really great way of putting Mr. Trump's actions. So he didn't reach out to try to get verified information because he didn't want it. He didn't want to actually have verified facts and information. So I think that that's important to remember. This was a pattern revealed throughout the investigation. Mr. Trump unquestionably accepted at face value the amplified election fraud claims that benefited his quest to retain power. Conversely, he avoided consulting informed sources such as state election officials who possessed evidence that could debunk his claims. The office concluded that this consistent pattern would constitute powerful proof at trial that Mr. Trump knew the claims he was making were false. So this is the piece, everyone, where Jack is setting out. This is his modus operandi. This is his MO. When he is in a situation where he's losing, he will make stuff up or not get the true information out there that could debunk what he's saying. And he does that for a whole bunch of stuff, not just for this election. So in the beginning, they were having some fights. Jack and Trump were having some fights over how much information could be used for past bad acts, right? We kind of talked about that before a little bit. Under the rules of evidence, you have to be very careful about showing past or prior bad acts. But this MO on how he goes about gathering information that's only beneficial to him could have been an excellent argument in front of a jury here. Mr. Trump's false claims were often divergent from one day to the next and otherwise internally inconsistent. For example, in Arizona, the conspirators started with the allegation that 36,000 non-citizens voted in the state. 5 days later, it was beyond credulity that a few 100,000 didn't vote. 3 weeks later, the bare minimum was 40 or 50,000. The reality is about 250,000. Days after the assertion was 32,000. And ultimately, the conspirators landed back where they started at 36,000, a false figure that they never verified or corroborated. And in Georgia, the conspirators initially suggested that a large enough number of unalive voters had cast ballots to overcome Mr. Trump's losing margin of about 12,000 voters. 1 month later, the number was 10,315. 3 days later, after that, the assertion was close to 5,000 people. And then 2 days later, the number bounced back to 10,315. So he was bouncing all over the place with those numbers. My goodness. Mr. Trump bears legal responsibility for each of these false claims because they were made by him and his co conspirators in furtherance of the conspiracy that he led. So, and then we have our citation here talking about conspiracy. The partners in the criminal plan must agree to pursue the same criminal objective and may divide up the work, yet each is responsible for the acts of each other. And then that also goes under a federal rule of evidence 801D2E. So 801, for those of you that are interested, let me just grab this piece here. Wait, maybe, where did my federal rules of evidence go? I might have been reading it in my room the other day, as you do. Oh my gosh. All right, well, sorry everybody, I don't have it with me, but 801D2 and 802 and 803, those are our hearsay rules. So what they're pulling in here is, again, kind of this admission of bad acts. So that's what that particular rule is for those that are interested. All right, so then we've got US v. Broken Borough, US v. Tarantino, and there you have it. So, yeah, I'm sorry if I say the names wrong. Conspirators. I struggle. That's funny. All right, listener's choice. Is it conspirators or conspirators? The office developed further evidence of Mr. Trump's knowledge that his claims were untrue from witnesses who reported that he planned to use fraud claims before the election had even happened. For instance, in advance of the election, advisors told Mr. Trump that the election would be close and that initial returns might be misleading, showing an early lead for Mr. Trump that would diminish as mail-in ballots were counted. In response, Mr. Trump suggested that if that prediction were true, which it ultimately was, he would simply declare victory before all the ballots were counted and a winner was projected. He also made repeated public statements in the lead up to Election Day, in which he sowed public doubt in the election results, setting the stage for his later fraud claims. And Mr. Trump made his first statement claiming fraud in the election only hours after polls closed, when no investigations had begun, much less concluded. Right. Mr. Trump's intent in spreading knowing falsehoods, was further evidenced by statements he made to those around him. In private, in contrast with his public false claims, Mr. Trump made admissions that reflected his understanding that he had lost. In a private moment, Mr. Trump confessed to his family members that, quote, "it doesn't matter if you won or lost the election, you still have to fight like hell," end quote. When President-elect Biden appeared on television in November, Mr. Trump said to a staffer, "Can you believe I lost to this effing guy?" And when his own vice president declined to join the conspiracy, Mr. Trump berated him for being too honest. Because the evidence showed that Mr. Trump knew his claims were false, it amply satisfies the mens rea standard for a Section 371 charge. Mens rea means criminal intent. Which would be satisfied by the evidence that Mr. Trump either knew his fraud claims were false or that he acted with deliberate disregard for their truth or falsity. The concept of deliberate disregard, sometimes referred to as reckless disregard or reckless or deliberate indifference, has deep roots in the law of fraud. And then we're citing the fraud law. Here's one from 1870. Whether the party thus misrepresenting a material fact knew it to be false or made the assertion without knowledge, whether it was true or false, is wholly immaterial. For the affirmation of what one does not know or believe to be true is equally, in morals and law, as unjustifiable as the affirmation of what is known to be positively false. So, that's language from the 1870s. The concept is reflected in case law and jury instructions for the District of Columbia, as well as precedent from every other circuit. Citing for the case law here. Um, One criminal jury instruction from the District of Columbia, 5,000 or 5.200. Now, anytime you can pull a jury instruction, everyone, this is just a little helpful moment. If you are working in criminal law or supporting people in criminal law and you're not quite sure what's needed for a particular case, of course, you would pull up the criminal law section. But if you want more details, you would pull up the criminal jury instructions in your jurisdiction. Incredibly helpful. Also, there is a what we call a bench book that the trial judge has with all of the different ways to rule on different objections. Also important and available to the public, usually. Here, the evidence showed that Mr. Trump decided even before the election that he would allege outcome determinative fraud, whether it occurred or not, if he were not declared the winner. And he adhered to that plan, repeating false claims that he knew to be untrue. Yes, the legal system struggles with absolutely. It truly does. It truly does. All right. So, although Mr. Trump's conduct fell comfortably within the established elements of a defraud clause offense, the office noted that the Supreme Court has, in several recent decisions, limited the reach of other federal fraud and obstruction statutes. And then they're citing Simonelli, which reversed a conviction on construction contractor for wire fraud for scheming with public official to tailor bid requirements for government contracts to favor himself because the government did not prove the defendant deprived the victim of a traditional property interest. All right, and then we've got the Kelly case, where there were convictions for wire fraud and federal program fraud, where defendants aimed to inflict political retribution on a mayor by closing lanes of the bridge that served the mayor's city, because the object of the scheme was not to obtain money or property. Well, that's interesting. Wow, that's interesting. So they're like, you're not doing what you want to do, so we're going to block your bridge? I mean, come on. What's happening in this world? I just don't even know. Oops, looks like I keep scooting the papers further and further down. Sorry, everybody. I got to get used to the format too, so I apologize. All right. Next, we have the skilling case, paring back honest services fraud statute here, 1346, to reach only core bribery and kickbacks, and reversing conviction of executive who was convicted of making false statements to inflate his company's value, but was not alleged to have taken bribes or kickbacks for his efforts. So that decision does not surprise me at all. And then Arthur Anderson, requiring a showing of knowingly corrupt conduct under obstruction of justice statutes, and reversing conviction of accounting firm convicted of shredding documents in advance of an SEC investigatory demand based on failure of jury instructions to convey the requisite consciousness of wrongdoing. So, wow, that's a lot in a case there. So that got overturned as well. These cases are bumming me out. Like the Supreme Court's like, okay, just do what you want to do, whatever. Thomas is like, just give me my cut. Given these decisions restricting the reach of other fraud and corruption statutes, the office considered whether the Supreme Court might also adopt a new construction of the defraud clause in Section 371, such as one that would, for the first time, limit it to money or property. So what he's saying here is that based off of what the Supreme Court's decisions have been, he was afraid to bring this in front of them because they could just change the law to whatever they want it to be. That's huge. This is a moment in time where we all step back and we know a special prosecutor who has done a ton of work in his life with a ton of experience has some misgivings about the Supreme Court actually following the law. So that's a moment. That's a painful moment here. Yikes. I gotta grab my tea here. Sorry, everyone. Because what you don't want are seasoned prosecutors saying, your Supreme Court's kind of off. That's like, you don't want that to happen. Oh my gosh. That, yeah, it's not, it's very unfortunate. All right. The office concluded, however, that the creation of such a new rule would not be supported in the law, given that the well established elements of a defraud clause offense were firmly grounded in the statute's text, history, and long-standing judicial precedent. For more than 100 years, the Supreme Court has, quote, stated repeatedly that the fraud covered by the statute reaches any conspiracy for the purpose of impairing, obstructing, or defrauding the lawful function of any department of government, and that this branch of liability is distinct from money or property limitations in other areas of fraud. And then he's citing the Tanner case out of 1987. Citation and quotes omitted. Then the Dennis case out of 1966. It's long been established that this statutory language is not confined to fraud, as that term had been defined in common law. It reaches any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. And then we're citing further on for Glasser, upholding prosecution of a federal prosecutor for conspiring to receive bribes to influence his official duties. No financial fraud against the United States was alleged. The indictment charges that the United States was defrauded by depriving it of a lawful government function by dishonest means. It was settled that this is defrauding within the meaning of Section 37 of the Criminal Code. So again, he's just setting out what the precedent is. So that, again, makes you a bit leery when you think he was worried about this going up to the Supreme Court and having all of that overturned by this particular Supreme Court. Then we have the Hammerschmidt case again. To conspire to defraud the United States also means to interfere with or obstruct one of its lawful governmental functions by deceit, craft, or trickery, or at least by means that are dishonest. It's not necessary that the government shall be subjected to property or pecuniary loss by the fraud, but only that its legitimate official action and purpose shall be defeated by misrepresentation, chicane, or the overreaching of those charged with carrying out governmental intention. And one more case here, it says it's not essential that such a conspiracy shall contemplate a financial loss or that one shall result. The statute's broad enough in its terms to include any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any departmental government. Oh, thank you so much, John. Oh, look at that. Thank you. I appreciate that. Remember to, right. Click the thumbs up. Yay! Love that. Love that. All right. So I think that's enough of the law discussion to give you a good idea of how he was going forward on that. So I do want to kind of fast forward a little bit to some other pieces. That was just the first count. So we've got 4 counts here. So let's kind of speed through these a little bit. Next, we have obstruction and conspiracy to obstruct. And this is where I had set out our inchoate offenses, right? So y'all are probably getting sick of me talking about the inchoate offenses, but they're so important and people forget them. And I feel bad that they get forgotten. But inchoate offenses are those offenses where we do not have the actual crime completed. All right, so that's conspiracy, attempt, and solicitation. So he's setting out here that we've got an obstruction and a conspiracy. The federal statute prohibiting obstruction of an official proceeding makes it a crime to corruptly alter, destroy, mutilate, or conceal a record, document, or other object, or attempt to do so with the intent to impair the object's integrity or availability for use in a official proceeding, or 2, otherwise obstruct, influence, or impede any official proceeding or attempt to do so. A separate provision defines the term official proceeding to include a proceeding before Congress. So let's pause for a minute here, because we had this huge question that went up in front of the U.S. Supreme Court, and I can see Fisher's already set here, where there was some controversy, because it seems when you read the statute that way, it looks like, well, it's required to have the actual document itself in play. And so Fisher kind of got away with it, or that piece of the code didn't particularly apply to his fact pattern. But when it came to Mr. Trump, he actually did have something in play. He did have documents. He was trying to do certain things. So this is where Jack's going to say that Supreme Court case on Fisher is not applicable to Trump. And that was a huge question that we were dealing with in this. So let's talk about Fisher. In Fisher v. U.S., so it's a U.S. Supreme Court case, decided during the pendency of Mr. Trump's immunity appeal, the Supreme Court clarified the scope of an obstruction offense under Section 1512c2, holding that the statute applies only when a defendant impairs or attempts to impair the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding. In language that applies directly to the allegations in the superseding indictment, the Supreme Court explained that Section 1512c2's criminal prohibition includes creating false evidence. So this is another piece that they pulled right out of that case. Before seeking the original indictment, which, like the superseding indictment, alleged that one component of Mr. Trump's and co-conspirators' obstruction involved replacing valid elector certificates from the contested states with false ones that had been manufactured, the office anticipated the possibility of such a result in Fisher and confirmed that the evidence would prove Mr. Trump's guilt beyond reasonable doubt, even under a narrow interpretation of 1512c2. So he's giving us the backstory here, everyone. You may not remember, but when Fisher hit the fan, everyone was scrambling to see whether or not we'd be able to keep that charge, that 1512c2 count against Mr. Trump. And what he's saying here is that they had already made a plan for, if that happened, what they were going to do, how they were going to go forward. So that was really important. And he's just explaining here, we were already covered. We already had it set. We knew this could happen, and we planned accordingly. So, which again, I think is great to kind of close up that, situation where we weren't sure, like, what's happening? In construing Section 1512c2 to reach impairing or attempting to impair the integrity or availability of records, documents, or other objects through creating false evidence, the Supreme Court cited U.S. v. Reich. That was decided by Sotomayor, Reich, I don't know, in which a defendant was convicted under Section 1512c2 after he forged a court order and sent it to an opposing party. What? Intending to cause that party to withdraw a mandamus petition, then pending before an appellate court. Oh my gosh, that's so bad. That's so bad. I'm going to have to read this case, everybody. Note to self, read this case, because that sounds like a really bad situation. So hold on, let's just break this apart a little bit here. So this guy forged a court order to the other side saying you need to withdraw your mandamus petition. Mandamus means that there's a request for some government actor, a judge, attorney, whatever, to be told specifically what to do because they're not doing their job. Oh my gosh, this sounds really interesting. So yeah, they don't like it when you like forge orders. That's like a bad thing. We don't do that. We don't do it. Well, I mean, we're not supposed to. Who knows what Giuliani would do? Just as the defendant in Reich violated Section 1512c2 by injecting a false order into ongoing litigation to which he was a party, the evidence showed that the co-conspirators created fraudulent electoral certificates that they intended to introduce into congressional certification proceedings on January 6th to obstruct it. So there we go. We've got the case law set out on a very similar situation when it comes to those false certificates. And so again, that puts Mr. Trump in that range outside of what the U.S. Supreme Court had said in the Fisher case. So that was a really smart way of looking at it, and I'm glad they had some case law there. So again, I'm going to fast forward a little bit. Again, here's our third charge, conspiracy against rights. Actually, this is going to be our fourth charge. I forgot. The other two charges went together. I think that's how it goes. Let me just double check. I thought the conspiracy against rights was the last charge. Maybe I'm thinking of a different case. There are a lot. Let's just double check here. Let's just double check. My table of contents. Okay, conspiracy. Yeah, it is the last one. Okay, yeah. So what I just went through, everybody, was both of the subsections of 1512, 1512K and C2. And so then we're moving on to the last one. Oh, phew. For a minute there, I was like, what? How'd that work out? So this is the last count, all right? So we had one count, two counts in the last bit, and then this is the last count in the indictment here. Got to get to bed, driving my... Oh, hey, that's all right. It's so good to see you, though, Estelle. I'm glad you could come over and hang out for a little while. I really appreciate it. It's good. We're going to be doing a lot more over here, so it's nice and quiet. That's really nice. Really, really nice. All right, conspiracy against rights here, 18 U.S. Code, Section 241. So this is our piece where we've got violations of civil rights. Section 241 makes it unlawful for two or more persons to conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States. So, and I've said this before, this piece is actually part of the act. I just call it the Klan Act, when it was put in to basically go against the Klan, who were trying to push people away from being able to vote, or make it so that they couldn't vote by doing certain awful things. So this is from that set of laws that were passed at the time to try to help with that. So, this is a pretty significant civil rights violation. A violation of 241 requires proof of three elements. Mr. Trump entered into a conspiracy to willfully injure, oppress, threaten, or intimidate a person in the United States. 3, the exercise or enjoyment of a right secured by the Constitution or federal law. And then we're citing the Epley case here to 1995. Oh, I'm still scooting. Sometimes I don't realize how much schooling. The overhead projectors. Oh my gosh, that's true. Let me get my pen, and then I'll just lick my fingers and erase it, so I can have all the pen markings on my face. Oh my gosh. Oh, good times, good memories, good memories, good times. Oh my goodness. All right. So we'll jump back into this because it's a civil rights. Mr. Trump's conduct meets each element. The right to vote for president based on the determination by state legislatures to appoint electors based on their constituents' votes is fundamental. And we're citing Bush v. Gore here, of course, landmark case, and Burdock, which was pulled by Bush v. Gore. The right to vote is the right to participate in an electoral process that is necessarily structured to maintain the integrity of the democratic system. And then U.S. v. Robinson here, Section 241 prohibits interference with a voter's right to cast a ballot for his or her preferred candidate, and prohibits interference with the right of voters to have their votes free from dilution by unlawfully procured votes. So it's a lot of language saying that voting is a privilege and a right. It is a right rooted in the principles of accountability to and consent by the governed. And this consent by the governed piece is a direct line out of the Declaration of Independence, which has distinguished this nation from its founding. As the Supreme Court has recognized, the right to vote freely for any candidate of one's choice is of the essence of a democratic society, and any restriction on that right strikes at the heart of representative government. And then we are citing the Reynolds case and the Yikwo case. These are just standard constitutional law cases here. Westbury v. Standards out of 1964. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which a good citizen we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. So the most important of all of the rights too. So with that, it's very important. All right, Mr. Trump acknowledged that voting in a presidential election is a fundamental right under the Constitution, arguing that urging states and Congress to use their power to select or to count electors does not affect the fundamental right to vote because it does not arbitrarily value one person's vote over another, and that's the Bush v. Gore case, or restrict the exercise of that right. Rather, it encourages the states and Congress to exercise their constitutional prerogatives a certain way. Indeed, given that all the states have made the popular vote an integral means of appointing electors, the right to vote in a presidential election is among the most precious federal rights protected by the Constitution. And that comes out of the classic case in 1941, when a state makes a primary election an integral part of the procedure for the popular choice of a congressman. It becomes a right established and guaranteed by the Constitution. And then we've got Trump v. Anderson. So this was the Colorado case where they pulled him from the ballot and the Supreme Court said you got to put him on it. So here's a quote coming from Colorado here, and it's saying the uniquely important national interest in a presidential election because the president represents all the voters in the nation. This history of Section 241 offense, which Mr. Trump was charged, along with the court's universal and long-standing recognition of voting rights protected by this statute, confirmed that protecting the right to vote is critical to the existence of the right. So, and then again, we go on a little bit further. I am going to skip ahead just a little bit. I'm going to start here because he's going further into how voting is a right. So, which I think is great, but yeah, we know that. So we're going to move forward a little bit. So next up, then we have defenses. And I'll probably go ahead and stop after defenses here because that's taken us through the first two Roman numerals. So let's take a look here. Before presenting the original indictment to the grand jury, the office considered Mr. Trump's potential defenses to these charges, including a good faith defense and advice. And see, this good faith defense isn't going to hold much water in a lot of states. Maybe only in federal court could you get away with using that. An advice of counsel defense and constitutional defenses. The office concluded that each of the defenses was legally or factually flawed and thus would not prevail. And that's a huge piece of getting your case ready. Like you may think, oh, we got to spend so much time to put this case together, but a lot of the time you're using to prepare battle plans for what the other side might come in and argue. First, it was expected that Mr. Trump would argue that he acted in good faith when he sought to stop the transfer of presidential powers because he genuinely believed that outcome determinative fraud had undermined the election's integrity and caused him to lose. Everyone remember that? As set forth above in Section 2A, the office developed strong proof that Mr. Trump knew that his election fraud claims were false. So now we're kind of getting into the weeds of what's going on to see what that analysis would look like, what we would have seen had this trial gone forward. So, for example, Mr. Trump made persistent claims of a large number of dead voters in Georgia. Hey, look, I can say dead because we're on YouTube. I'm very excited about that. Including in his speech at the Ellipse on January 6th, even though his senior campaign advisor and Georgia's Secretary of State had told him that the claims were untrue. He spread lies, including in his Ellipse speech, of sinister fraudulent vote dumps in Michigan, even after Michigan's Senate Majority Leader told him that nothing suspicious had occurred. And Mr. Trump repeatedly made provable false allegations about fraud in Pennsylvania, despite having been told by the chairman of the state Republican Party that the vote count was occurring as expected. So even if Mr. Trump maintained that he sincerely believed he won the election, a conclusion unsupported by the evidence collected in the investigation, it would not provide a defense to Section 371 charge. A defendant may not use deceit to obstruct a government function, even if he believes the function itself to be unconstitutional. because a claim of unconstitutionality will not be heard to excuse a voluntary, deliberate, and calculated course of fraud and deceit. Whoa, that's really powerful too here. All right, so he kept saying, well, the information that I was getting was saying that we had all these problems. And so what Jack Smith is saying, it doesn't matter. It doesn't matter what information you were getting. That's not part of the rule that you broke. All right. And then we've got another quote here. One who elects such a course as a means of self-help may not escape the consequences by urging his conduct be excused because the statute which he sought to evade is unconstitutional. There are appropriate and inappropriate ways to challenge perceived illegalities, just as the president of a company may be guilty of fraud, oops, and he was, for using knowingly false statements of fact to defraud investors, even if he subjectively believes that his company will eventually succeed. Oh my gosh, I totally thought he was going to be citing one of Trump's business cases here, but he didn't. I was waiting for it. Wait, let me make sure. Yeah, nope, these aren't his cases. Mr. Trump could be convicted of using deceit to obstruct the government function by which the results of the presidential election are collected, counted, and certified, even if he established that he subjectively believed he had reason to do so because of his claims that the election was rigged. It bears emphasis that Mr. Trump's knowing deceit was pervasive throughout the charged conspiracies. This was not a case in which Mr. Trump merely misstated a fact or two in a handful of isolated instances, like 30,000 square feet instead of 10. On a repeated basis, he and his co-conspirators used specific, knowingly false claims of election fraud in his calls and meetings with state officials in an effort to induce him to overturn the election in their states. To his own vice president, to induce Mr. Pence to violate his duty during the congressional certification proceeding, and on January 6th as a call to action to the angry crowd he had gathered at the Ellipse and sent to the Capitol to disrupt the certification proceeding. Mr. Trump and co-conspirators used other forms of deceit as well, including when they were falsely represented that the fraudulent elector votes would be used only if Mr. Trump prevailed in pending contests in their state. And when they caused the fraudulent electors to falsely swear that they were duly certified and send those false certifications to Congress. Regardless of any claim that Mr. Trump subjectively believed the outcome of the election was unfair or rigged, the office concluded that these knowingly deceitful statements would overcome any good faith defense. All right, so the good faith defense, which again, good luck using that in a state court, but they're saying the good faith defense could be overcome at this point. All right, and with that, everybody, I can tell that I'm going to need to break from reading tonight before my vocal cords go out on me. So let me put a little post-it note here. Now, here's my question, though, that I have for everyone joining us tonight, and I appreciate you all coming in and hanging out with me tonight. That's really cool. Moving over to our other platform. But here's my question, then, that I would ask of the chat. We all had significant fears when it came to what happens if Kamala wins, right? So if she wins, what is Mr. Trump and his, pack of people, what are they going to do? What level of violence were they going to use? What kind of things were they going to do to try to overcome or overthrow democracy, right? So I'm wondering, here's my question, my thought that I keep having. Are we, even though Mr. Trump's policies and what he's going to be doing are going to be rubbish and difficult to come back from, but we will, is that better than this idea that had he lost, he would have burned it all down? So that's kind of my philosophical thought. Like, no, I don't think it's a good call to have him in office, but a silver lining could be at least everything's not getting burned down because he lost. We would have another round of this was a false election, this was a fake election. All of the court cases that would follow with that, all the prep work that they all did to try to overcome the actual votes, we didn't have to deal with any of it because he's now in office. What are our thoughts about that? I'm just curious. I'm just curious. Right, right. Okay. And for reading. Oh, of course, of course. Context is very important. Context is super important. Putting out the fires would be easier than 4 years of mess. Oh, that's a good point, Kaya. That's a really great point on an 11th hour save. So that's a good question, Misty. I heard or saw something going around that somehow Biden could come in and extend the deadline for TikTok, right? Have people been hearing that? That somehow Biden had that authority to do that? Hope Congress comes in. Oh, Congress. Okay. Yeah, I've been hearing yeah, I think that Congress will definitely help with that because its numbers aren't strict. Okay. So, let me clarify. The way that this law was put into this humanitarian package, we all know that they just slipped it in trying to be jerks. But Biden doesn't have the power or authority to change a deadline set by Congress. And the example I would give you would be the Equal Rights Amendment, right? The Equal Rights Amendment had everybody sign it and everything was done, but missed the deadline. So there was this idea that Biden could come in with an executive order and get rid of the deadline or push the deadline further. But then, of course, all of the attorneys are saying, and all of the debate is saying, he does not have the authority to do that. Very similar situation. The president does not have the authority to override a congressional deadline. That deadline could only be overturned or moved or changed by Congress. So, unfortunately, there's been this talk about, oh, maybe he'll come in and change it. Biden cannot. He doesn't have that kind of power. Even if he did try, it would be going through the courts anyway to see whether or not that was actually legal, and it's not because of our division of authority and our division of powers. But it's possible that Congress could, although they did not agree to that later in the day. The Senate said he had to change the date. Is that what you're saying? Yeah, and that's just not true. That's just not true. And what bugs me is when the Senate says things like, well, we don't need to convict him. He'll go down the criminal road and that'll be fine. So the Senate screws up a lot. All right. Yeah, the Senate, no, there's nothing in the law, the way that the law is written, that Biden could come in and say, I'm going to change a statutory deadline set by Congress. Like he just doesn't have that kind of authority. Congress could, and I don't know what the Senate's talking about because I worry that they don't even know what their own power is at this point. But no, I think they might be trying to twist it so that we could blame Biden for it rather than the Congress that set it out. What about the indigenous people? For what? I'm sorry. That was my retort that he has. Right, exactly. And you're exactly right, Navy vet. You're exactly right. They have to change it. Right. If Congress does it, then Congress has to change it. If he does it through an executive order, if he writes something out and wants it changed, he has to put another executive order in. Right, right. That he can't come back again has some appeal, though. Yeah, I agree, Spencer. I agree. I again, we're at that place now where we're saying if we can survive the next 4 years, one foot in front of the other, then we wouldn't have to worry about him running again. First of all, which would be great. But I don't. It would be great. But again, we have to get through those 4 years and the kind of damage. And I know a lot of people, especially some older people that I've been speaking to, that are so worried. They're like, it's going to take at least one or two generations to undo the harm that Mr. Trump has done. And, I don't know how I feel about that because I feel like anytime any of our presidents can shift and move things around in certain areas that will set us back, nothing to the magnitude of what Trump can and will do. Don't get me wrong. But, I think probably every generation would say that, particularly when FDR was in office, where he kept getting reelected over and over and over again. And the people were like, well, it's going to take us decades to get back to where we were. That's my thought, at least. Can SCOTUS change the deadline? No. SCOTUS will only decide whether or not it's a violation of the First Amendment. That's it. That's it. They cannot change the deadline on any of the cases in particular. Um, I've seen some situations where they have come in on cases and said, like, you didn't answer this question, you need to go do that. So they can give some directions or directives to people, but deadlines are sacred in the legal world. Oh, here I am, Lorraine. I'm here. I'm here. I don't think that's a good question too. I'm not really sure. But if you think about it, he's like, what? We talked about this before. I can't ever remember how old he is. He's like, what, 78, 79, 80? I mean, he just had a birthday. He's an old man. And I'm not just saying that based off of years. I'm saying that based off of lifestyle choices. And I feel pretty comfortable with that. But yeah, they got to say something by tomorrow. I know. Yeah, you hope so. You hope they would. But he's pretty old. So, and there's nothing wrong with being old, but when you put someone really old into like the highest stressful job you can get, like imagine if he was like air traffic control, right? I'm trying to think of a really stressful job. Like if he's in air traffic control and he's not even the one on the microphone, he's the one like signaling the planes, that's not going to be good for his health. That's not good. He's not going to be able to do 4 years of landing planes. So we got to kind of think about it that way. Like, what's going to happen to this guy? Because I don't know. they can they can stay until they do more investigation. Well, right. Exactly. That's definitely a possibility because again, they're under the wire. They know that this is coming into play on the 19th and that it's going to seriously affect a lot of people. And, they've got what, 1 week to think about it. I agree. It seems like 78. Okay, thank you so much. I can't remember which side of 75 he was on. What do you think about living presidents going to inauguration of a traitor and or the flag for Carter? So here's my thought, and I hear what you're saying because there's rumors going around that the flags may be put back up for his inauguration, which I think would be very disrespectful. And on the other hand, too, I know Michelle Obama's like, I'm not going. And I think that's okay. I think that's okay. I think if we are too rigid with our traditions, then we struggle to move forward then. And you don't want to be disrespectful to that kind of a position, to those kinds of situations, even though Mr. Trump is extremely disrespectful, but it's not really about him. It's about you. And so if you're like, look, I'm just not going to go. I can't support this. I can't support what just happened. I think that's absolutely fine. But the flags going up would be very offensive to me, but not making it to or going to his inauguration, I think everybody has to check their mental health. And if their mental health is like, I can't do this, then you can't do a goodbye live on. I will. I will. Oh, John. Oh my gosh, it's so sad. I will. I'll be doing a good. I'll probably actually be doing a TikTok live tomorrow night, actually. I'm going to try to hop back on a little bit each day. But yeah, I'll be coming in to say goodbye. It's so sad, everybody. It's so sad. I'm so bummed out about it. No, it's okay. It's okay. Gotta deal with reality. Deal with reality here. I'm not dealing with it very well. My husband came home today and he's like, "Why is mom's head on the ground?" And so one of my people was like, "It's TikTok." And he's like, "Oh, get away from her." Like, I know. Oh my gosh, it's heartbreaking. It's heartbreaking. Biden said leave the flags. Yeah, I think that would be best. I mean, let's be respectful. If you want your flag at full glory, too dang bad. We still have we still have some rules here. Don't be disrespectful of the flag. And Trump, though, who knows? Because he's like got his name all over his flags and he's like giving them hugs and inappropriately touching the flags. So I don't know. He doesn't have a lot of respect for the flag, quite frankly, unless it can make him some money. So I'm not really sure what's going to happen. It is petty. I agree. I agree. It's very petty. Like, get over yourself, man. Nobody's going to be watching. That's the other thing, too. I just saw Midas Touch just did a post and they said, look, we're not going to be streaming the inauguration as part of our, like, we're not going to deal with this kind of crap. I was like, you go, Midas Touch. And I also have our Declaration of Independence, everyone. I'm going to try to do that live as the last live before everything goes. So that'll be good too. I know, exactly. I know. He was he was humping the flags. He's inappropriate. He's an inappropriate fella, you know? He's like your kind of gross grandpa. I know y'all are, you know what I'm saying when I say that. HGTV or something. Yeah, for 4 years straight. I know. Well, we've got to put some defenses up. I think that's important. So I've got a new colored map that I'm going to be bringing in to go through all of the legal changes that they're going to try to do every day. I'll try to blow some of that BS away, but yeah, I think this could be a good learning experience for people who don't know how government works, or they're going to be trying to figure out like, wow, maybe my vote should have been done, you know, rather than staying at home. So I think that, you know, we're going to learn. We're going to be in a learning situation. You just have to make sure that you're protected and that you won't be harmed by what's coming down. Um, I watched the new episodes of Traitors. There you go. Oh, there you go. Yeah. Oh my gosh, Kentucky's had some weird stuff going on over there in the last couple of days. Goodness gracious. Wow, you've been in the news, Kentucky. That's some craziness. We can't do our Declaration of Independence during his inauguration. I know that was kind of what my plan was, but we'll do it before. We'll do it before the inauguration. Again, I've got the 27 original complaints and then the 29 that we added. So I'll get it put together. I'll make sure I post it up here on the tube of you as well on YouTube. Oh my gosh, it's gonna be rough, everybody. It's gonna be real rough. So I think you just need to make sure you're watching your mental health. And, we're having a 1-2 punch hit. So, make sure you have all of your creators that you enjoy. I've got all of my ballerinas on the YouTube now because I love to watch the ballerinas in their shoes. And I love all the dancing because I'm a dork. So I had to make sure. I'm like, okay, Stray Kids, you're also on YouTube. Hi. Just make that crossover happen. And then just remember, you're like, okay, they're still here. We're still all here. We just had to move over a little bit. They kicked us out of our house. So we got to do that. Jack's report will probably have 1,000 more. Oh, I know. Yeah, so I do want to finish up this. I will probably just summarize the highlights to remind everybody here. And quite a bit of this is actually these 2 letters at the end. So what I might do is just finish up with the letters. But I have to tell you, now that we are over on, oh, you're so sweet. Oh, thanks. While we're on the topic, I've got a special surprise as kind of like a, here we are on YouTube situation. I'm pre-filming, and I wasn't able to do this for TikTok because there were just too many problems, but I'm going through the chapters and getting them put together in a playlist for P25. So I've been trying to do that for a year, and I've just never been able to sit down, record a whole chapter, and then upload it. But that's going to be my grand opening, will be to have, I'd like to get at least half of the chapters read and then posted before the big switch happens. So I'm able to do that very easily on this app as opposed to the other one. So I'll be doing that, and we'll be getting into the deets on a lot of different things. So Declaration of I know. Oh, well, you're all very, very welcome. They're not in the use. Oh yeah, that's the other thing too, isn't it? Oh, I know. I know it's painful, everyone, but we'll make it through. We'll make it through. So I will be back to kind of finish up and wrap up this report. I will be over on TikTok to do our Declaration of Independence, and I will do I will do a goodbye video when the time's right. Oh my gosh, everybody, this has been such a crazy ride, but I'll be here. I'll be here over on the YouTube every day, so you can catch me over here. But with that, I should probably sign off at this point. Whole new, yeah, exactly. No. Well, we can't send them to Australia. Australia has already said no thanks, and so is Canada. Oh my gosh. Yeah. I've got a few surprises in store to kind of triage the situation. So, oh yeah. I've got much more words I'm going to be able to say here. Many, many more words. So I'm excited about that. All right, everyone, take care. Have a wonderful night. Thank you to my moderators for coming over here and hanging out. I will be back on the TikTok tomorrow for sure. So I'll give you different directions if I'm going to be anywhere else. So take care, everyone, and I will see you all very, very soon.